Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, this morning we'll begin with the United States versus Gutierrez, and Mr. Eisler, I think we'll hear from you first.
Good morning, Your Honors. Counsel for the government. On behalf of Mr. Gutierrez, we are thankful for the chance to argue before this court today. He is serving a 40-year sentence. Man with 2 criminal history points. And although Mr. Gutierrez, as he argues in the brief, believes that substantively he's entitled to compassionate release, the main thrust of our argument here today is to ask for another opportunity before the district court to have all of his arguments heard and to be stated on the record. As can be seen from the order of the district court, which takes up about 1/2 of a page double spaced, almost no substance of Mr. Gutierrez's argument before the district court is contained in that order. There is no way to parse if any of those arguments were given any consideration whatsoever. And so we ask this court, based on its longstanding precedent, to find that there is procedural error because the court did not consider all of the arguments. Now, the government is quick to point out the High case.
Counsel, I'm sorry, before we move off the order, may I ask you just, I guess like a framing question. How do you understand the district court's holding in this order? Do you understand this paragraph to be doing a 3553A analysis and denying relief on that ground? Or did the district court find that there were no extraordinary and compelling circumstances? What exactly did the district court hold here?
I will be, Judge Harris, that's a fair question. To be quite candid, I don't know. And that's part of the concern or frustration is the form order doesn't indicate what that paragraph is for. Is it for the initial threshold for extraordinary and compelling reasons? Or is it for the 3553A factors? And that's at Joint Appendix 329 if the court wishes to look at it. So it's a quick read, but there's no way that I can discern. I know for what I do know is that there is no mention of the substantive arguments for extraordinary and compelling reasons that I can see. And so I'm not sure, because if it's not there, Your Honor, it's not anywhere, because there's no other substantive portion to the order. Everything else is a form, and there's no other boxes checked that I can see, except for where it says check either defendant or director of the Bureau of Prisons. And so to answer your question, Your Honor, I don't know. And that's really gets to the crux of our argument, Your Honor. We're not asking for this court to even opine as to the substance. I know this court more recently, and again, they've been mainly in unpublished decisions, has reversed for consideration under Concepcion, and the plethora of cases that have come down since this was decided by Judge Russell. And so for, when we talk about wanting to uphold the integrity of our courts from the client's perspective and from the public's perspective, procedural reasonableness is one of those things that really secures the ability to do that, because it allows the district court to make its own substantive determinations, but it allows this court to find out the why. And that
Let me ask you this. The standard that's been given to us by the Supreme Court is basically to give us sufficient information to review what the district court did. And what I've taken from the presentation to the district court and what the district court said is that there was not a heavy argument made about the COVID and the health risks that the compassionate release motion was made on. I think the argument was really this man has made substantial progress in rehabilitation. He has done a lot in that regard. And he's basically saying, I'm a different man. And I committed a big crime. So he's now, he had a 40-year sentence and he served 15 or 17 years or whatever. So he roughly wants half have his sentence released because he is a rehabilitated man. That's what I basically read the record to make. And what I saw the court doing is basically saying, I hear that. But as the state, the prosecutor, not the state, the government said, basically, this is one of the most serious distribution crimes they've ever prosecuted in the state of Maryland. And that it was very significant. And there are a lot of arguments made about the sentence, going back and reviewing the sentence in this case. But I don't think that's the role under compassionate release. I think the compassionate release question is its discretion balancing his grounds for being released against the sentence that was given him. And maybe I've oversimplified it, but tell me if where I'm wrong on that. I sort of sensed that from this record that the whole argument was this is a new man, a rehabilitated man, and I'd like to have compassionate release exercised to me, set free. Is that about it?
Your Honor, I would agree with you on one point that my client does say he's a rehabilitated man.
Yeah.
I would respectfully disagree on the other point because from a substantive matter on the extraordinary and compelling reasons for release, the vast majority of our motion and reply dealt with substantive arguments for extraordinary and compelling release, whether it be disparate.
Well, take me through that then. I thought he'd been vaccinated and conditions in prison were okay. And of course, we have a fading pandemic. And the questions at that time, it wasn't. Of course, it was at height. But it seemed to me that that wasn't pressed as hard as his point that he's done a lot to advance himself. And I think he should get credit for that. But ultimately, the question, I suppose, is, well, go ahead and make your point there. I might have misunderstood.
Well, you don't misunderstand the sort of, I guess we'll say, some of the equities in the case as far as his rehabilitation. So I'll take that real quick. And this is why it's so important in comparison to High, which I would understand why the government utilizes that case a lot. But from an equity standpoint and from a factual standpoint, it couldn't be more dissimilar. Your Honor hit the standard right on the head as far as, can this court make a determination of what the district court thought of our arguments for extraordinary compelling release and a final determination? And High does not diminish that in any way. High does not say that there is no procedural protections in compassionate release litigation. And in High, the gentleman had just been sentenced, I want to say within a year, and he was already given a variance, and it was done by the same judge. And the court said, well, there's not really, literally nothing has been changed. The facts couldn't be more dissimilar to my client, who'd been, at the time he requested, not 16 months from being originally sentenced, but 16 years. He was not given a variance. His case was on the cusp of the Booker case.
Well, that's on the merits. The question, you're making a procedural argument. And the question is, what was the standard in High? It was actually that language from the Supreme Court. Basically, what was the standard? Basically, we need to know, the record has to show that the court, what?
That the court needs to be able to make a determination and have a reasonable review of the case below.
Well, but counsel, that's not where, I mean, that is the standard, but we have, what's the right word, detailed that standard in cases like Martin, saying that when there's this kind of mountain of post-sentencing rehabilitation evidence, what that translates to is an individualized explanation that is robust and detailed. And I had taken your argument to be that we don't have that here, but I don't want to put words in your mouth. And I guess I would like you to tell me what you think that looks like. What is it we are demanding in cases like Martin, where we say, when you've got this huge and very significant, I think we called it a mountain of post-sentencing rehabilitation evidence, we want something more robust and detailed, something individualized. What do you think that requires?
Well, Your Honor, I think it would be reasonable to be more than one sentence. And
But you didn't get a sentence.
Well,
you got a
I believe it
clause.
was one sentence we're talking about is while the court applauds the rehabilitative efforts,
That's it. That's not a sentence.
it's a part of a sentence. And again, having this reversed for further consideration in a more robust order harms no one. Mr. Gutierrez is going to stay in the Bureau of Prisons and is going nowhere. It will take very little effort, and our system of justice will be, its integrity will be protected. I want to get back to the extraordinary compelling. This was not a mine run case, which I take that when this court is referring to high in cases after it, it says this is really for your more run-of-the-mill compassionate release cases. We didn't make, Judge Niemeyer, you're correct, we didn't make a run-of-the-mill, although we did mention his health conditions, they would meet, at the time would have met the CDC, and I think still those arguments hold up for the most part. But what we also mentioned for extraordinary compelling relief were the fact that there were disparate sentences at the time. There was no really variance information in the PSR. My client admittedly was an idiot at the time, beyond an idiot, and didn't participate. And so the court didn't really consider his background as far as I can see, and there were no variances. It is rare for the court not to consider a variance in the district court these days, or even back then, without some kind of consideration of a variance. And the fact that this reviewing court didn't get into any of that with them, again, going back to the merits, this mountain of rehabilitation, he's been a mentor, his family has seen changed. His letter, he admits to committing the crime. There's no hemming and hawing. He's not going to try to do any post-conviction 2255. He did this crime. And he is remorseful for the way he interacted with his trial attorney, but this court has seen that kind of interaction before. There can be a lack of trust. My client grew up in South Central LA in an environment that, respectfully, I think I can presume that none of us could really imagine, to immigrant parents that did not speak English. But there were multiple, the other extraordinary compelling reason that we listed were that the sentence that he received was not consistent with, since we get today, people have murder sentences that are shorter than this. So there were multiple extraordinary compelling arguments that were not even given one word of breath on the order.
Can I ask you about one of the few things the district court said about your client specifically? The district court said the defendant was compensated in the millions for his efforts. Are you aware of any evidence in the record that supports that statement? That he was not that he trafficked millions of dollars worth of drugs, but that he was compensated millions of dollars?
I could not find it. I could not find it anywhere, Your Honor. And I you know, all I have is the order. I can certainly believe that there's some.
Well, presumably the district court had to base that on something. Do you know where that came from?
Because it wasn't referenced, and when I took this case, Judge, obviously I had a lot of years on it, and we are panel counsel. We took a lot of these cases. This is one that definitely is the one that keeps me up at night. But I could not find any reference to compensation. It sure wasn't reflected as I.
Well, wasn't a search produced over a 1.6 million, one particular search? I mean, this is ongoing conduct, and they found at one point in time 1.6 million.
It's my understanding, as from the facts, because it was a trial, we did not have an agreed statement of facts, so they kind of summarized it in the PSR, which happens after trials. But it's my understanding that there was some large amounts of cash, both from the Baltimore prong of this, which were people that lived there that received about a half to a quarter of the sentence that my client received. And there definitely was large amounts of cash, but this was an alleged drug organization. There's no indication that my client was the head of this organization. The people involved in these drug organizations incur great risk, as can be seen by the sentence.
Yeah, but I thought it was the search in connection with the Maryland operation, not the Los Angeles and the cartels.
And my understanding is that money
and the amount of kilograms was extraordinary. I don't know if I've ever seen a case with so many kilograms of cocaine involved in the big picture. But I'm talking about in the Maryland structure, they found about $1.6 million in cash on a given date.
I will review the record, but I also know, I guess back to the question of Judge Hayden's, was my client ever compensated in that amount? I have no information that my client, there are people that mule millions of dollars worth of drugs for $1,000, a couple $100. I don't have any information to support. And that kind of goes to the reasonable, the abuse of discretion, is that's a fact that I could not find in the record.
All right. Well, you got some rebuttal time. We'll hear from you. Mr. Medinger.
Good morning, Your Honors, and may it please the court. Jason Medinger on behalf of the United States. Your Honors, the district court here properly exercised its discretion, and we respectfully ask that this court would affirm. I'd like to jump in first with a question that was asked.
Could I actually start with you with a factual question that I just wasn't able to run down?
Certainly, Your Honor.
Is there any indication that the district court reviewed the original sentencing transcript before resolving this motion?
So nothing in the record to say that, Your Honor. So I don't have any information one way or the other. What I will say for this court is the judge that decided this motion was different than the one that was the original sentencing judge. So I do want to point that out, but I don't have it either way, Your Honor.
And similarly, do you know why the original sentencing transcript does not appear to be in the record?
I don't, Your Honor. What I do know is that these transcripts, this case was tried at a time before all the transcripts were electronically available. So I think that has mostly to do with it, Your Honor, that I don't think it was ever ordered previously. And when this case was being prepared, no one asked for the transcript.
So you think we need to decide this case under the assumption that the district court did not review the original sentencing transcript?
Well, I think under Legree and a couple other things, we can say that there's a presumption that the district court considered all the relevant factors. But in terms of that specific question that you're asking, Your Honor, I just don't think we can say either way. Unfortunately, it's just not in the record.
Okay, thanks.
But what I will say, Your Honor, is I think if you look at the record here to some of the questions that Judge Niemeyer was asking, what we have is a 3553A analysis that sees this defendant as someone who is top of the charts in terms of what the offense conduct was. So if you look at his guidelines, he was given a level 38, which is the highest you could possibly go under 2D 1.1C. It stops at 450 kilograms of cocaine. This gentleman was trafficking 500 to 600 kilos of it. So he was at the absolute top of what the guidelines recognize in terms of offense conduct. He was also somebody who was a manager, organizer, and leader. So we got a bump for that. His guidelines would be the same today if he were tried today. And so I guess in the government's view, there really wasn't a whole lot that was different. He certainly had mentioned COVID-related concerns, and that got him past the extraordinary and compelling circumstances threshold. But once you get into 3553.
Okay, counsel, I'm sorry, can I just stop you there? So that your understanding is that what happened in this case is that the district court found that there were extraordinary and compelling circumstances, but then denied relief under 3553A?
I think the best reading is to say that the court assumed without deciding that.
Where would I find, I'm perplexed by this order because it doesn't say that. So, but you were there, or maybe you feel that from the context, that is the best reading of this order?
So I do, Your Honor, and to be
Okay.
clear, it wasn't a proceeding. This was just a written order.
Oh, right.
that was
So there
entered.
is no context. Okay.
But that's fine, Your Honor. So if you look at just Joint Appendix page 329, where it is, you look at what he's discussing there, and it's all the 3553.
It looks like 3553.
He's
Okay.
discussing the nature of the offense,
But then-
seriousness,
okay.
deterrence.
And you think if the judge had found that there were not extraordinary and compelling reasons, rather than either finding that they were or assuming that there were, it would say something about that?
Correct.
Okay.
And we have case law on that. I believe, High and Jenkins were both cases where courts essentially assumed the extraordinary and compelling prong and jumped right.
yeah,
into
there's
the
lots of
consistent-
cases. Sorry, there's lots of cases that do that, but the judge says, I'm assuming it, and then jumps. I'm just trying to figure out literally what happened.
Right, Your Honor, I guess my retort to that would be, if you look at what's there, it is singing to the 3553A factor.
I agree. That reads like 3553A to me. I'm just trying to figure out what happened on extraordinary and compelling.
Correct. And I guess in our view, he almost is ticking through them, A1, A2, A3. You sort of see him going through that analysis. So I think that's the best reading of it.
Well, on that front, can I ask you the same question I asked your friend on the other side? What is the best evidence in the record for the proposition that the defendant was compensated in the millions? Not that he transported in the millions, not that he even at some point had physical custody of proceeds. I mean, my understanding, limited though it may be, of how drug trafficking organizations work is that lots of cash goes through them. That doesn't mean that individual people are being compensated for all that money. So what is the best evidence for the proposition that this defendant was compensated in the millions?
So the best place I would point you to, Your Honor, is Joint Appendix page 338 and 339. That's the PSR, which is what my colleague, Mr. Eisel, mentioned. That's really all we have. And all it suggests is the seizures, one that Judge Niemeyer mentioned, the $1.4 million seizure of a downstream customer, Mr. Brooks, that was at Mr. Brooks's house.
But that's like if I'm a clerk at a jewelry store and the police search it and find all the money and then say I was compensated all of the money that was in the safe. That's not how employment relationships tend to work, right?
So you're right on that, but the one difference to the hypothetical I would mention is Mr. Gutierrez wasn't a clerk. He
Sure.
was an owner of this DTO. He was the right-hand man to Mr. Gonzalez, who had the contact down to the cartels. So in my view, Mr. Gutierrez had an ownership share, and all that money that was flowing into and out was.
There's some sort of partnership agreement that says he gets 33% of the money. Do we have something like that?
There's not.
Well, compensating doesn't necessarily mean profit, does it?
It does not.
Compensating could be gross compensation, and it's indicative. The judge was pointing out the level of the offense. And it seems to me that this man clearly had control of over $1 million, million plus, and it was a reasonable thing to say he was compensated, whether by his customers or by his suppliers. It doesn't matter. He had control of millions.
Correct. So that is the best we have in the record, Your Honor. But I do think that's the appropriate measure. But separate and apart from the money angle to it, again, I would point back to just the kilograms upon kilograms. A bi-coastal relationship. We're shipping things from LA to Baltimore in these big electronic shipping containers. This is a large DTO. So it's a fair inference, I think, from the record.
Can I jump to the end? The district court says the public needs to be protected from the defendant. What is the evidence that supports that, particularly given that the BOP rated his risk as low?
So if you look at what this defendant was doing, I think that's what the court mentioned, and it marries up to the other point that the district court made about how the drug trade in and of itself, especially of this nature, is one that leads to violence. And he was quick to point out there's no violence specifically with Mr. Gutierrez, but the judge is saying in his experience, generally, violence follows from the drug trade. And this individual was involved in it at some of the highest levels. And so I think when he's talking about protection of the public, we can't have this kind of large-scale bi-coastal cartel working here. Violence is inevitably going to follow.
Well, I guess, counsel, I think what you're just saying is very helpful, but I think it helps illustrate to me my concern about what the district court said. There may be very good arguments for why this individual is different than a typical narcotics trafficker, why it doesn't make sense to give him compassionate release. But we're putting an awful lot of gloss on what the district court said. And when I read what the district court actually said, other than the words millions of dollars, and I'm not sure where that comes from, I'm hard pressed to figure out why you couldn't give this explanation to deny compassionate release to virtually any narcotics trafficker, right? Like, what is in this other than the compensated in the millions, which I'm concerned may not be reflected in the record? What in this explanation is at all individualized and couldn't just apply to any large narcotics trafficker?
Well, actually, I think it's quite individualized in the sense that we're talking about the factors that Mr. Gutierrez was involved in. Not every trafficker is involved of this ilk and this kind of level. So in that sense.
No, I'm not talking about the facts of his case. I'm talking about in the district court's explanation. So he says he was a large scale narcotics trafficker. That presumably applies to any other narcotics trafficker. Responsible for putting massive amounts of narcotics on the street. That also seems to describe any narcotics trafficker. There can be no dispute that narcotics trafficking contributes to much of the death and violence occurring in this country, true of every single narcotics trafficker. He's not violent. That's bad for a not denying compassionate release. The court applauds his rehabilitative efforts, which presumably is going to be true of everybody who did anything. Others, like the defendant, need to be deterred. That doesn't apply to anyone. That's not individualized. The public needs to be protected. That's not individualized. So I'm just concerned about what about this doesn't. Again, I'm not talking about the facts of his case. I take your point. There may be reasons why this individual is different. But when I look at what the district court said, I don't see an explanation that doesn't apply to any narcotics trafficker.
So what I would respectfully disagree with a couple of the averments that you made, Your Honor, about how some of these factors would apply to every trafficker. I don't think so. There's actually traffickers that are lower level traffickers. And I've been prosecuting narcotics crimes for a good long while. I've never gotten someone to a level 38. Typically you have someone and
But the district court doesn't say he's a level 38. Again, that may have been a valid reason, but the district court does not say that.
Well, you said large scale trafficker and that's all we have. But I guess what I would say, Your Honor, is to some of the points you were making, we are here on abuse of discretion standard. And this district judge looked at these facts and said, in my view, this is how I'm going to exercise my discretion. He does not get compassionate release. And once we're into that standard of review, even if this court would say in the first instance, I would go a different way, we still have to affirm under the abuse of discretion standard. So I think that's where we are. I do want to just mention very briefly about this procedural reasonableness argument that my colleague is making. I think if you look at High and Jenkins, those cases say very expressly that the district court doesn't need to touch on every argument that's being made by the defendant. And so I think that forecloses this idea that there has to be large scale discussion of every COVID argument that he's making or argument in mitigation. That requirement just
Counsel,
isn't there.
I agree with you that there's no sort of requirement of large scale discussion of every argument he's making. I am a little bit troubled that there's no reference at all to COVID and conditions of COVID, both sort of a prisoner's risk as to COVID, but also that the conditions of confinement change as a result of COVID. And I think we've said in a couple of cases that when a district court does the 3553A factors, you need to sort of account for COVID in that analysis. We did say in High that there are cases where we can just sort of infer that consideration took place. Are you saying this is one of those cases?
I think it is, and I think I would go back to High. High, I think, is very close to this case in terms of what was said. I think in the Jenkins case, this court described the High decision as simply a paragraph, and we affirmed in High. And here you have a very similar response from the district court.
Yeah, but it doesn't mention COVID, and this does go back to my concern about whatever happened to extraordinary and compelling circumstances. I think because we don't have any, because the defendant raised those mostly in that context, and because the district court never said anything about what was happening over on the extraordinary and compelling circumstances side, I find it harder to kind of just infer, well, what happened was he understood the COVID risk. He assumed that was important to we just don't have anything indicating any kind of attention to the COVID issue.
Understood, Your Honor, but I don't think it should trouble you, and here's why.
Okay.
Under any analysis, this defendant has to meet first extraordinary and compelling. He's got to exhaust. Then he's got to get through 3553A factors. So there's three prongs that he needs to win on. If he doesn't win on one, game over.
No, I understand that, but the COVID is supposed to be taken into account even if the district court is just deciding this on 3553A grounds. We can infer that happened if there's some discussion of extraordinary and compelling circumstances that might indicate, oh, I was paying attention to COVID over there. But there's just nothing anywhere about COVID in this order, and that's my concern.
So there's not, Your Honor, but I guess in my view, if you could look at High and Jenkins, I don't think he has to. If these other factors are discussed and they move the needle and such that he doesn't make it under 3553A. The other thing that I'll just mention, Your Honor, is I think if you look at Joint Appendix page 36, that is the initial motion for compassionate release that was raised by the defendant. That's where he discusses the 3553A factors. And if you look at the district court's response to that, it's responding to the 3553A arguments that were made by the defendant. So in other words, my point is, I think it's clear that the district court said, I'm going to grant you that you meet the extraordinary and compelling prong. Now I'm going to focus in on what you raised as the 3553A factors, and I'm responding to them in my order, which is what he did. And if you look at it, it's a very short discussion that Mr. Gutierrez makes on 3553A. And so the district court responded to that, again, in a very short order that looked at all the factors. So I think what you have here is enough, as Judge Niemeyer said, to look at it and see what the district judge was doing and what he was thinking. And I don't think there's any reason to send it back. We also made a harmless error argument.
Before we get to that, can I just ask you about the Martin line of cases, the cases about the post-sentencing rehabilitation evidence? Because I do take your point that the sort of the facts of this offense are very unusual. On the other side of the balance, this does seem like an unusually significant amount of post-sentencing rehabilitation evidence. I'm not sure I've actually seen anything quite like this. And we have said, you know, it's everything from getting an associate's degree. He's learned these trades. He's a teacher. He's a mentor. No infractions in 17 years. As Judge Heitens pointed out, the Bureau of Prisons itself says he is at a low risk of recidivism, which is something I might have expected the district court to address when he says, I think that's wrong. Basically, I think the public needs to be protected from him going forward. I disagree with BOP. You know, we say in cases like Martin that when you have that kind of a mountain of evidence, we are looking for an individualized explanation that grapples with that evidence, a robust and detailed explanation. And how do we have that here?
So two things I would say.
I don't see any, I guess I just follow on. I share Judge Heitens' concern that this clause, like, oh, I applaud your efforts at rehabilitation, could have said that about anyone who's taken like one high school class in prison. That's my concern.
Thank you, Your Honor. So two things that I would say to that. One, if you look at the high case, I think Mr. Gutierrez ranks up close to that individual. There was some discussion in high about how the gentleman, you know, got his GED in prison and had done some vocational training. I haven't looked at it and cataloged it, you know, who took how many courses, but I think in the opinion, Mr. Gutierrez is not completely dissimilar from Mr. High.
Really?
The second thing I would say is, you know, we're here on abuse of discretion. And so this judge said, I applaud the fact that you've availed yourself of certain programming, but that still just isn't going to outweigh what you did. You know, you engaged in this large scale trafficking. You did a flesh and blood defense at trial. Basically,
I'm sorry, is this the high case you're talking about?
this is this case, Your Honor.
This report didn't say that. The flesh and blood, what?
Well, you know, it's not in the opinion, but I'm talking
Okay.
about this individual. About
But I'm talking about the explanation we had. So if I was genuinely confused, I thought maybe I was looking at the wrong case.
understood. Your
Okay.
Honor. So in any event, I think this judge is looking at the conduct and saying, I appreciate the programming that you've engaged in. That is great. That is what we hope folks do. But it still doesn't outweigh what you did. And that's an exercise of discretion that I think if we were to reverse that, we would be robbing the district court of the discretion with which they're vested.
No, we wouldn't. We'd be saying you have the discretion. You just have to actually provide an individualized explanation in this case.
Right. And I guess where I'm disagreeing with that is I think he did. And he said, this is how I'm exercising my discretion and this is why I'm doing it. And so we think that that is sufficient here, especially on this record and especially considering this court's precedents. I'll just mention briefly that we did raise a harmless error argument. So despite the idea that we would like a more fulsome opinion, we would always like more fulsome opinions. But if you look at this record, it's clear that it's not an abuse of discretion to deny relief here. So we cited a case, the Santana case, where a court said, yes, there was some procedural error, but we're still going to affirm. So we would respectfully ask under any of those prongs that this court would affirm. And if there's no further questions, I'll cede the rest of my time.
Thank you, Mr. Mantinger.
Thank you, Your Honor.
Mr. Heisel.
Thank you, Judge. I just wanted to pick up where one of the points that Judge Harris made, and how the extraordinary and compelling reason for relief sort of flows into the 3553A factors. And again, as your honors know, these things were coming at a breakneck speed, and the panel, we handled so many of these, and this was a more meaty one. And the extraordinary and compelling arguments in this were 3 to 5-fold, dealing with, and we argued it was a combination of factors, not, and I think Judge Niemeyer picked up on this. This was not just a COVID conditions, although we were explicit in listing what exposed him. We talked about the fact, very unique things, different from McCoy, but McCoy is still the law. And so when we talked about the fact that, for example, it didn't seem that, well, we know the trial court didn't seem like they had all the information about his original upbringing, growing up in South Central LA, exposure to all this violence, because my client was an idiot at the time. The fact that there were disparity among co-defendants of the sentences, the fact, as Your Honor mentioned, horrific conditions due to COVID. These are all relevant factors, and they all flow into the 3553A factors. From a stylistic standpoint, should there be a sentence that said all of these kind of matter for 3553A? That maybe could have done a better job, but I think they're all relevant because they impact the overall decision, whether or not this is extraordinary and compelling reasons.
Is it your position that we should review the original sentence? I mean, those arguments seem to focus on the original sentence.
No, Your Honor, I'm not asking to, I'm asking for a chance.
I mean, you talked about the disparity and so forth. Of course, his guideline was life imprisonment.
That's correct, Your Honor.
Yeah. And
no variances were considered, as I can tell, Your Honor.
well, I understand, but my question is part of the analysis require us to go back and decide whether he was properly sentenced in the first place?
I think part of the analysis is for the district court to meaningfully review what we argued to the district court, and that's all we're asking. We're not asking to burden anyone. The court could very easily say, you know, I'll tell you what I was thinking, let me expand upon it. That's all that we are asking, and there is no one harmed by the request. We're not getting into, as Judge Hayden described, we're not impeding abuse of discretion. If anything, we're allowing the court to expand and add more faith into the system by giving an order that's more than one paragraph double spaced. And the argument was taken from me by the Judge Hayden's before. You can hold that order up to any case, and you would not be able to determine whether or not, unfortunately, the district court even read the many substantive arguments in our motion and reply. It's just not there. And the last things I would like to point out is that procedure directs substance. And that's why this court has been clear that it's so important that the district courts explain their orders. I'm not asking for a fine-tooth comb in this case. I'm just asking for a comb. I just an acknowledgement as these arguments that are made. And so that's all that we're really talking about here. We're not asking the court to get into the weeds of the substance. Of course, it's there. I mean, I can't hide it. I echo Judge Harris' sentiments. I have not seen this kind of rehabilitation, mainly the length of time that has taken, the amount of rehabilitation that he's done is so dissimilar to the High case. And I've exhausted that in the reply brief, but there is almost no similarities. And I think the Concepcion case in this court's previous cases in the First Act context, I think was the McDonald maybe in the other cases, there's no reason to veer from that. I think that the High case can't tell this court that procedure doesn't matter because in my view of the case law, it would change precedent and we would need an en banc decision. And so again, we're not trying to get the court to the merits. We would just like a court order that reasonably addresses our arguments in good faith, and procedure matters. And we mentioned the Mitchell case from the same district court. This court reversed that, and the court, I checked on it, changed direction and granted compassionate release. And so the importance of procedure is maybe the district court didn't see it. Give the district court an opportunity to review things that maybe it missed because it didn't follow the procedure, because that's what happens. If you don't review things sufficiently and you get a second chance, you could very easily change your mind. And so we're asking not bind the district court, but free it up under our current precedent. We thank you.
All right, thank you, Mr. Eisel. I notice you're court appointed.
Yes, Your Honor.
And I want to recognize that this is a very, very important role. And of course, it makes our system special, and you've done a fine job. And I want to thank you for that. Our normal practice would be now to come down and greet counsel. And we're still under many of our COVID restrictions, and we've retained that one. So we won't come down this time, but I promise you the next time you come, we'll come down and shake your hand and greet you and welcome you. And maybe even remember your attendance here today. I thank you very much. We'll proceed on to the next case. Project versus Wilson, and Mr. Smith, whenever you're ready, we'll hear.
May it please the court. Of course, I will certainly do my best to answer any questions that this court has. But what I would like to address first is why we believe that these statutes meet whatever standard of vagueness analysis is applied to them. As the court knows, there was a lot of discussion of that in our briefs, and we rest on our briefs. I'll be glad to answer any questions on it. But we believe that regardless of which standard, Hoffman or fair notice or legitimate, plainly legitimate sweep standard applies, these statutes meet that standard. The disturbing the schools statute has got limitations imposed on it within the statute itself and also by the South Carolina Supreme Court in the Amir case. The Amir case said that to prosecute somebody under that statute, that it must be an offense that disturbs the learning environment.
Can I ask you a question about Amir? And I think it goes to a lot of the way I'm thinking about this case. So we held in Kenny that Amir doesn't really purport to announce a limiting construction of the statute. It comes up in a different context. That's not what it's doing. Are we bound by Kenny?
I looked at that, Your Honor, and I do not believe so. I think that was limited just to analyzing the cases for purposes of determining standing. Anything beyond that, I think, would be dicta, because what Amir holds would be going to the merits of the case. So I think that this court has the discretion to view Amir differently as to that without overruling prior panel decision. Amir was an overbreadth case, but not a vagueness case. They didn't reach vagueness, but the learning environment standard that they found applied to that statute is something that would apply regardless of whether it's overbreadth or vagueness. And it's certainly consistent with what the statute says it is. It's a disturbing the schools statute. So it's not a leap from there to say conduct must disturb the learning environment. It also, under the terms of the statute, must be willful or unnecessary. The plaintiffs, appellees contend that unnecessarily is vague, but I think by analogy, we can look to the football penalty of unnecessary roughness. It's not just any roughness in a football game. It's roughness that's unnecessary.
Well, counsel, I thought your argument about willfully or unnecessarily was that there's a mens rea requirement in this statute.
Well, it certainly requires a criminal level of conduct in that terms. If you look at the whole statute.
Wait, I'm sorry, just so I understand, I thought in your brief, tell me if I misread your brief, you were arguing that willful is a mens rea requirement for this statute. Is that not your position?
It does have to be willful. That would be.
I don't understand. I don't understand that. If it says it has to be either willful or unnecessary, how is willfulness a requirement? Why isn't it sufficient if it's unnecessary?
It does not have to be both. It can be unnecessary.
So then it doesn't have to be willful.
It does not have to be. If it is
Okay.
willful, that meets the terms of the statute.
But it doesn't have to be willful.
It does not have to be willful.
So there is no mens rea requirement.
Well, I think when unnecessarily requires.
You think unnecessarily is a mens rea
Well,
requirement?
it requires a heightened level of misconduct.
But it does not have anything to do with mens rea.
Well, it doesn't unnecessary in this context mean gratuitous. In
Yes,
other words,
Your Honor.
and actually in Bartlett's synonyms book, not Bartlett's, there's a synonyms book that says unnecessarily is willful. While the dictionary definition, I didn't see it there. I looked up just one dictionary, but the synonym was unwillful. But if you read it in context, when you say unnecessarily disturbs, it seems to me that's gratuitous.
I agree with you, Your Honor, and I think that it was certainly not intended to lower the standard below willfulness. It was to address something that was gratuitous. If a student injures himself in class and says, ouch, that may be disturbing the school, the learning environment, but it's not willful or unnecessary. If a student yells out some word in the middle of the class that is completely unnecessary or volume that's unnecessary, then that would be unnecessary. That would be disturbing to the environment.
Can I ask you that? So you just brought up the example of a student who yells out something during class, which from my recollection of being a student is not an infrequent occurrence. So what is the difference in the state's view between criminal disorderly yelling something out at class and standard variety you get sent to the principal's office yelling out something unnecessary in class? How is anyone supposed to know where that line is?
Well, I think that, well, first of all, it has to be unnecessary, and words alone are not punishable unless they are fighting.
I can literally summon to mind dozens of examples of grade school through high school where students did something in class that by any conceivable definition is unnecessary.
Well, I think you have to look at whether it's really disturbing to the learning environment. If there's like just one utterance or something like that, that's probably not disturbing. And I think
But this is a criminal statute. Is probably not disturbing. Like, I don't understand. Is that the best we can do in terms of answering Judge Heitens' question? For kids on the ground, they should just know if you yell once, that's probably not going to get you sent to prison. It might, but probably not.
Well, I think you have to look at the whole context of this statute and look at the whole statute as a whole, as the courts do when they're construing statutes, that it's intended to reach a criminal level of misconduct. And apparently, most students in South Carolina, more than 99% of them get it, because in the last reporting year, 2019-2020, less than 1/7% of the students were charged under here. Apparently, most students.
But apparently most citizens in Chicago got the loitering statute it issued in Morales, and that's not enough to prevent a statute for being unconstitutionally vague, is it?
Well,
And isn't the concern, like the fact that most students get it, the concern that we identified in Kenny is that most students probably sit there and don't say anything because they don't know when they open their mouth whether they're going to prison or not.
well,
Like the fact that people can censor themselves and chill their own speech to avoid coming close to a line that hasn't been defined for them is not a helpful thing. It's the problem, as we explained in Kenny.
Well, I think that the chilling of the speech is the speech is not chilled because it's limited to fighting words. Words alone cannot be punishable unless they're fighting words. And I think beyond just the statistics of less than 1% of 1/7 of 1% of the students have been charged, these are old statutes. The disturbing the school statute in pertinent part has been in effect for over 100 years. The disorderly conduct statute has been in effect in pertinent part for over 70 years, and they have never once been overturned. So,
Do you know how long a whole bunch of loitering statutes have been in effect before they were declared unconstitutional?
no, I don't, Your Honor.
I suspect it was a really long time.
But I think you've got multiple factors here to uphold the disturbing the school statute. The words alone, which I've mentioned, the statistics, and the fact that the statutes have not been overturned. I'll be glad to answer any other questions about that statute, but I'd also like to talk about the disorderly conduct statute too. Our position, it requires a criminal level of misbehavior. It requires punishes a person for conducting himself in a disorderly or boisterous manner. I believe the plaintiffs focus on the word boisterous, but you construe the statute as a whole, it is looking to a criminal degree of misconduct. It punishes gross.
Counsel, I just want to make sure I'm understanding because I'm confused. This is a criminal statute, so it just seems it's sort of circular to say we define it like the thing that puts people on notice and the thing that gives standards to the school resource officers who are enforcing this is that it should only be applied when the behavior reaches a criminal level of conduct. I mean, that's the whole question in the case. These students need to know when will my behavior reach that level of conduct. So yeah, that's my
I understand your question, Your Honor. And we would
Is this
We all
one
do.
being applied, this is the as applied challenge, right?
Well, Your Honor, we take the position that although they call it an as applied challenge, it is functionally a facial challenge because it applies to 800,000.
I understand that, but it determines our analysis. And as I understand that both the your colleague on the opposite side and the district court concluded that this particular challenge was not a facial challenge, but an as applied challenge.
Well, we respectfully disagree with that, but regardless.
Well, let's assume it is. Whose conduct are we measuring then?
Well,
It's
Your Honor,
SPs, right?
it would be student conduct, but there is a variety of student conduct here. We set
I
forth.
thought it was only SP was the only plaintiff charged with disorderly conduct.
I believe so, Your Honor.
And the facts of her circumstances are she was being escorted, refused to leave the library on the orders of the principal, and then had to be escorted, and then said to the principal, F you, and then yelled to the whole library, F you.
Yes, Your Honor.
Okay.
We believe that's punishable under this statute. If looking at the whole statute, it punishes gross intoxication, not just intoxication, gross intoxication. It punishes discharge of a firearm near a school or on a highway without just cause. And I believe that is also limited by intoxication too. So it requires a heightened level of misconduct before it falls under the statute. And disorderly, boisterous manner would certainly require a heightened level of misconduct. Students would be on notice that they have to meet a heightened level of disorderliness, boisterousness, essentially common sense.
So could you tell a student, and let's put to one side the students, what about this, the school resource officers? Can you give them any more concrete guidance than it has to be a heightened level? That seems self-evident. Instead of going to detention, you're going to prison. Probably it requires something heightened. Can you be any more concrete than that? For just say I'm a school resource officer, I'm like, I don't know, he shouted in class. Does he go to detention? Does he go to prison? What do you tell the student resource officer?
If you look at Captain Reinhardt's testimony.
No, I'm just, what can you tell me is the advice that a student resource officer ought to get beyond heightened?
That he would look to the totality of the circumstances, what was going on with the student. Was it words alone? If so, they would have to be fighting words. If it was something that was significantly disruptive, that would be something that could be taken into account.
Would you agree with me that it's not super common to define a criminal offense based on a totality of the circumstances test?
Well, that's what the courts apply, respectfully, Your Honor.
No, I'm just trying to think of other crimes where the difference between criminal and non-criminal conduct is an all things considered totality of the circumstances test.
Well, Your Honor, I can't think of a particular example right now, but I think when you look at this statute as a whole, when it punishes gross intoxication, firing a weapon while intoxicated.
I don't think there's an argument, right, that the subsection about firing a weapon while intoxicated is vague, or is there?
I'm sorry, no, there's not, Your Honor. It's just those are factors that show that there is a heightened level of misconduct required.
So you think, what you might, I don't want to put words in your mouth. So what you might tell your student resource officer is only conduct that reaches the level of firing a gun while intoxicated?
No, Your Honor.
Okay.
It would have to be disorderly that is of a height.
So that example really doesn't help.
So we believe that informs what level of conduct is required. And I think.
But it doesn't have to be that high.
Doesn't have.
It doesn't have to be as disorderly as firing a gun while intoxicated. You're not saying that example gives us the limit.
Other
Okay.
kinds of misconduct beyond that.
Okay, but we don't know which kinds.
Other types of misconduct beyond being grossly intoxicated. But I think that you do have to consider those factors when you consider this one. And the cases have said that the fact that law enforcement officers or even courts might disagree as to how a statute applies does not make it invalid. And we believe there's sufficient guidance in the case law, in these statutes, to uphold them. I'll be glad to answer other questions on that.
Well, I think we're through the red light and
Okay.
you do have some rebuttal coming.
All right, thank you.
Yeah. All right. Mrs. Hinder?
Good morning, Your Honors. Sarah Hinger on behalf of plaintiffs' appellees. The concern with vagueness under the Due Process Clause is not whether or not the subject matter of arrests is a significant concern that the public might want to address, or whether or not an officer exercised their discretion appropriately in an individual case. Rather, vagueness points to the requirement that the legislature spell out through the law itself objective standards of conduct that permit for even-handed enforcement and provide notice to the individuals, in this case, school children, of when their conduct can be subject to criminal penalties. There are additionally important factors in this vagueness case. As Your Honors recognized, the penalties under this statute are criminal in nature. The conduct covered by the statute also incorporates important First Amendment speech and expressive conduct. And it also regulates school children as it's applied, and not, for example, a knowledgeable business entity that could be expected to consult business regulations before acting. And so all of these factors caution additional concern in examining these laws for vagueness. And what we have here in this case, and as the district court recognized, school children are criminalized for being, under the terms of the statute, disorderly or boisterous, and under the disturbing schools statute, disturbing, obnoxious, interfering, and loitering. And these are terms, particularly in the school context, that do not give an objective standard. So in schools, as our briefing argues, there is an expectation that students may sometimes disobey school rules, that they might be considered by adults in authority to be disorderly or boisterous. And there's expectations for how a school will interact with a child and address those behaviors. That's a unique condition of the school and school-child relationship. And there is no way within the terms of the statute for anyone, for a child or for a police officer, to decide when disorder of a child rises to the level of criminal. And the terminology suggested of a criminal degree of misconduct or significant disorder are merely additional subjective glosses. They don't provide an objective identification of conduct that the officer, the student, anyone would be able to point to in any incident where the law has been enforced, that regardless of one's personal philosophy on enforcement and intervention, would indicate that the South Carolina legislature intended for this conduct of a school child to be subject to criminal penalties. And that is the fundamental concern under the enforcement of each of these laws against students. And
Counsel, you're sort of focusing on application, I guess, of the disorderly conduct law to school children. And when you say that your case, I think you argue that this is an as-applied challenge. You mean as applied to the class in this case, which is all K through 12 students, is that right?
yes, Your Honor. We sought and received class certification and specifically posed the legal question to the court of the application to K through 12 students in the school setting. And the district court, consistent with what this court identified in the white coat case, looked at the factors that govern the contours of an as-applied challenge, whether or not the application should be reviewed by the circumstances and the individual to which it's applied, and it tailored its remedy similarly according to that scope of application it reviewed.
Does it matter to your case whether we view this? I mean, it is an as-applied challenge, but as applied to thousands of people. So does it matter to you whether we consider this as applied or facial? Does it make a difference to the analysis? It seemed like everyone conceded below. It wouldn't really make any difference.
The legal standard will be the same regardless. I think the difference is just that the plaintiffs have asked the court only to look at the statute in this particular context, which allows the court additional factual and particularized consideration to rule in the narrowest sense that the plaintiff.
Right, because this statute can still be applied under this injunction. The statute, you can still apply it outside the school context. Someone else can be arrested for whatever it was, being boisterous.
Yes, that's
okay.
When we do an as applied, we look at the facts of the particular case, right?
To the extent that they color the
not color. There's been a charge against somebody for particular conduct.
Well, Your Honor,
we're talking about, we don't go down gratuitously looking for statutes and throwing them out.
Yes.
And as applied, we look at the facts of the particular case. And in a class action, you can look at the class representative. You have to start with the class representative in order to identify the class.
That's correct,
And
Your Honor.
in this case, the class representative is one person. It's a female, SP.
The class representative is SP as well as DD, Your Honor. But I think
Well,
that
DD did school disturbance. The disorderly conduct was is only represented by, if I understand it, by SP. We have DS was charged with this school disturbance. DD was charged with school disturbance, and SP was charged with disorderly conduct.
I think, Your Honor, the important issue, which was directly considered also in this court's standing, is that the class plaintiffs, representatives, and all members of the class aren't challenging the application of the law in the past.
The class members can't do the challenging. Yeah, I mean, the class is represented by the representative parties, and the representative parties' conduct has to be typical and common for the class. I mean, this is just fundamental Rule 23 stuff. So the question is, I know you prefer not to do that. It seems to me you just want a legislative veto in the third branch, but we got to have a case or controversy. And in this case, with respect to disorderly conduct, the class representative is SP. And we look at SP as applied to determine whether the statute is unconstitutional. And if it is, then she gets to, and regardless whether it is, she gets in her circumstances to represent a class of persons similarly situated. And she is alleged she's representing a class similarly situated. Now, the fact that the class includes people that aren't even threatened with enforcement of the law is a significant problem, but I don't want you to answer that question. I really want to focus on the analysis in an as applied challenge to a statute enforced against SP.
Yes, Your Honor. So one part of the enforcement is the threat of enforcement ongoing.
It wasn't a threat. She was charged.
Okay, but if we take the charges against SP, I think that the question here is not, again, whether or not one individual or another would believe that she deserved to be arrested. The question is
whether the statute as applied to her was unconstitutional.
Yes, Your Honor. And the question
is based on vagueness.
Whether it's clear and objectively clear that there was particular conduct in SP's case that was objectively disorderly, objectively boisterous. And there's simply no particular letter of the law that would allow someone to objectively determine that. And this is similar to what the Supreme Court found in US v. Johnson. There might be certain violent crimes that a vast majority of people would agree without a question are violent. But the problem is,
What happened in SP's case? She was charged with disorderly conduct. What were the proceedings thereafter?
she was charged and adjudicated delinquent.
And so the argument has to be that that proceeding went through, I suppose, a level of process, and that the statute applied to her in her circumstances was unconstitutionally vague.
There wasn't a question of vagueness raised in her juvenile adjudication, but again, here it's important to note that the plaintiffs and SP did not challenge or seek to vacate any condition of her adjudication. The plaintiffs are seeking.
Not the plaintiff, we have a class representative. Understand the class action. Class action is not all these other people in court. They are represented by the representative party, and their situation is adjudicated by the representative party because they are similarly situated.
Yes,
So
Your Honor.
we have to start on this as applied in a lawsuit against brought by SP, alleging that the disorderly conduct as applied to her was unconstitutionally vague.
Your Honor, so respectfully, this district court found that SPs had standing to challenge the
I'm not
statute.
talking about standing.
Thereafter, the question of class representative is whether or not the class representative raises common questions of law.
And her
typical
case is
concerns,
typical.
and can reach common conclusions. And any one of those things can be grounds for a class certification.
I'm sorry, you
is
have to go
within-
back and read 23A. You have to meet all 4 criteria. And
And-
then you have to meet the B criteria also, in addition to 23A. It's not the general notion that you have common questions.
And within the district court's discretion found that there were a common consideration that each student attend school under the threat of enforcement under these laws. Each plaintiff and class
You
member
have to have a
raises.
specific threat of enforcement according to the Supreme Court or standing to challenge a criminal statute.
Yes, Your Honor, and
Okay.
and this court did find that to be the case specifically regarding SP.
So every person in that school is specifically threatened with enforcement of disorderly conduct. That's what you have to be alleging.
Yes, that is what we allege, Your Honor. And it chills their attendance at school, which school inevitably involves, for example, boisterousness, which could govern and has been applied to speech and conduct in a school cafeteria, which, as we know from the Supreme Court's recognition in Tinker, is an important place where students engage in fundamental speech rights. And how this statute can objectively determine what is criminally boisterous versus permissible or subject to school intervention is just not present in the statute itself. And as my esteemed opposing counsel pointed out, these statutes are many hundreds of years old. We are not looking here at.
And they've been enforced
statutes.
for hundreds of years, including by the Supreme Court.
And we're not looking here at statutes that were crafted recently with a specific intent and focus on addressing school conduct. In fact, there's no reason to believe that when the legislature enacted these terms that they meant to address these things. And the problem is that they're far too open-ended, particularly in this school context. And so it may well be that the South Carolina legislature and the community of South Carolina through the legislature could determine that it seeks to regulate student conduct in some particular way, including criminal law. But to do that, it must establish objective standards in the law that makes clear that it intends for particular types of conduct in school to be criminalized. Otherwise, each act of enforcement requires a subjective judgment, whether or not that subjective judgment is handled with appropriate discretion or not. Each act is too dependent on subjective decision-making. I'll turn now to the question of the scope of relief, just to note that after finding a constitutional violation here, the district court was well within its remedial discretion to remedy the violation found and directly contoured the relief to the harm found. So for example, at Joint Appendix 937 through 38, the court recognizes the continuing and ongoing harm, including adverse housing and education consequences. And defendants in the reply brief admit that the court has authority to issue class-wide relief as well as expungement, just not both on the facts of this case. But that's speaking to the district court's discretion here. And there's no case identified in which a circuit court overturned a district court's discretion in determining whether or not expungement relief.
Can I ask you a question? We have on appeal at this point, we have DS, SP, and DD as the individuals who are charged. Did any of those three raise constitutional challenges to their charges?
Well, Your Honor, both DS and DD had the charges against them dropped. So in particular, without standing as was found in this case, they wouldn't have had an opportunity to raise those constitutional challenges.
And did SP raise a constitutional?
To my knowledge, no. I wasn't her counsel in that case.
Counsel, can I ask you a question about the expungement order or injunction? I know we're using expungement as kind of a short form. What is the district actually required to do? It's not retain or use the records?
Thank you, Your Honor. Yes, the expungement is a shorthand here, and the relief is tailored particular to South Carolina statute that governs expungement, and that does not require the destruction of records. The principal relief is against the use of those records against students in the future.
Is there a process in the statute, the expungement statute, that has to be followed?
If an individual were to seek expungement on the basis of their unique circumstances through South Carolina law, there is a process. There's separately a process for how records will be handled once expunged. In this case, the expungement flows from the finding of an unconstitutional criminal statute.
I understand, but the question is, if you have a person whose statute has been found unconstitutional and they want to go and have it expunged, what do they have to do?
It is expunged by order of the district
What's the
court.
process? They make an application and then what happens?
No, that it's by direction of the district court. However, as indicated in the court's order at Joint Appendix 948.
No, I'm asking you under the expungement statute in South Carolina. You said there's a process. I'd like to know the process.
Well, if an individual were to seek expungement in South Carolina as a juvenile, they would have had to reach the age of 18. They would have to have no other conviction on their record, and they'd have to pay $310 as of the last time I checked in order to seek expungement from the court in which they were convicted. In this case, if there were any complicating issues, the district court specifically retained jurisdiction to be able to address those. None have come to light.
So the district court's going to be the expunging court as opposed to the state administration?
Yes, Your Honor, this is a remedy to a violation of federal law.
I understand that. That might be a basis for expungement, but you said, for instance, one of the requirements is the applicant could not have committed another crime. And the question is, how is the district court giving honor to that?
That would be if an individual sought expungement on the grounds permitted under South Carolina's expungement statute. But
well, that's what we're talking about.
Respectfully, Your Honor, I don't think we are. The basis for expungement here is the finding of a constitutional violation. The courts are in broad agreement that expungement is an appropriate remedy where an arrest occurred under an unconstitutional statute, and that remedy flows from the federal constitutional violation, which as the Supreme Court found in Felder versus Casey, just for example, isn't limited or constrained by particular state procedures.
Well, we have a conviction of SP. And the court is now going to set aside that conviction. Is that what you're saying? Even though that person was convicted under South Carolina law and had the opportunity to raise the constitutional defense. Is this a problem where the federal courts are telling the state courts are going back and undoing state court criminal convictions?
No, Your Honor,
I thought you were forward looking and using that as a basis.
Yes, Your Honor.
And if you're doing that, then you can't go back and expunge.
Well, and this is where the expungement shorthand is important to recognize, because we are not asking, and the district court didn't order vacator of any sentence. It's the prohibition against forward-looking use of the records.
Well, what about SP? Is her record being expunged?
Her record would be expunged to the extent of forward-looking, but there's no.
Well, she was already convicted. And the question is, we don't know whether she committed another crime. We don't know whether she satisfied the other criteria. So basically, a federal court is vacating a state court criminal trial.
Vacator, again, is not at issue here. There's no question or concern with SP serving out whatever terms came from the district court there. The question is the ongoing reliance.
What if she was still in prison?
From the records.
What if she was still in prison right now?
Well, Your Honor, respectfully,
what would our ruling have to be?
I wouldn't want to speculate. She's not in prison. Again,
it raises the principle.
Sentence.
It raises the principle. In other words, basically, you would have to bring a 2254, right?
I wouldn't want to speculate, Your Honor. There's no indication in the record that any of the students are incarcerated. If they were, that would be an issue at the first instance of fact for the district court to consider, as it indicated retaining jurisdiction to address any issues in the case. But that's simply not the facts that we have here. It hasn't been raised. It wasn't the case with SP, and there is no order to vacate any prior sentence from South Carolina courts. And I see that I've used my time. If there's
okay, all right, thank you. All right, we have some rebuttal, do we? Mr. Smith?
Yes, Your Honor. First, I'd like to talk briefly about class certification. We believe that there is no commonality, there's no typicality, and the relief does not benefit the whole class. And some of these reasons were touched on in the argument with appellees. We've got class.
I gather that the class is really defined by anybody who's in school.
Yes,
against whom these statutes could be enforced.
Yes, Your Honor.
And no other criteria. In other words, it's a little bit like saying the whole state of Maryland is a class because we all could be charged with speeding.
Yes, Your Honor. And in fact, with the class of 800,000 school students in South Carolina, that's bigger than the population of some states, I believe. There's not the same injury within the class and with respect to the class numbers. There are dissimilarities with it. As we point out with the statistics, less than 1/7 of 1% of the students have been charged.
It could be also the Supreme Court has allowed that if somebody is threatened or is engaging in conduct that could call on it, but we don't have that as defined as part of the class here. The class is defined simply as students.
That's correct, Your Honor.
Well, counsel, isn't that because of the sort of unique injury we recognized in Kenny? I think we held in Kenny that students in these schools do have sort of a cognizable injury because they don't know where the line is. Not like, if you shoot a gun while you're intoxicated, but in the mine run of cases, sort of normal student conduct, They don't know where the line is between what will get them detention and what will get them a prison term. And as a result, they all suffer sort of an ongoing injury in this moment of being subject to subjective enforcement and chilling their speech as a response. So I think once we have Kenny, that's why I sort of started with Kenny. Once we have Kenny, I guess I don't really see the problem with the class in this case.
Well, that was for purposes, as Your Honor knows, of determining standing. It's not with regard to the.
But it identified the injury, said it was cognizable, and now these class members are coming in saying, yeah, we all have that injury.
But it's really the class representatives who are asserting that on the benefit of, as to the whole class. And if you look at the whole class, they're not in fact suffering the injury because they're not being charged. They're not going through.
But that's not the injury from Kenny. That would be right, except for Kenny. And Kenny, we said that's not the only injury. There's an additional cognizable injury that is suffered by people who never get charged.
Well, respectfully, Your Honor, I don't believe that is controlling with respect to the class certification, with respect to the merits of this case. And I think in addition, the plaintiffs cite no case, I believe, that that shows that all class members are threatened in this situation. That the vast majority of students who do their schoolwork and behave are not threatened. In fact, the law is protective of those students. It protects them from the behavior that is covered by the disturbing the school statute and the disorderly conduct statute. And certainly, in addition to the problems with commonality, there's no typicality here. There is certainly, as a lot of the focus has been on the behavior of SP, certainly, I hope that is not typical behavior of South Carolina students. The statistics indicate that it is not.
The Supreme Court put this to rest. I mean, in its Anthony case, they basically said when you're challenging a statute under this, there has to be an intention to engage in a course of conduct arguably affected with a constitutional interest, but prescribed by a statute. And there exists a credible threat of prosecution thereunder, and then they say where threatened action by the government is concerned, they give them standing. And that to me is, in other words, you don't have a class of people that could be charged under a statute. And you have to have a imminent threat of prosecution. I think we would end up having every case, a class action, every case where a person was subject to its laws.
Yeah. I agree, Your Honor. We believe also that the relief here, as I said, does not benefit the whole class. I'd like to talk just briefly about expungement, the class-wide expungement. Your Honor had questions about expungement procedure in South Carolina. In the joint appendix at 225 and 226, we set forth that procedure here. In effect, this order granting sweeping expungement, while it applies to record keep, it in effect, without vacating these sentences, in practicality, it does, because it's off the records, except for the limited purposes for which records can be retained. The cases that have been.
Is it a requirement under South Carolina law that before you have expungement, the criminal conviction has to be vacated?
I don't believe so. Person may not petition if the person's had a prior adjudication for an offense committed by an adult. A prosecution can file an objection to it. So it would be a one offense type application, I believe.
My question is, though, before the state expunges records, does the record have to relate to a conviction that's been vacated?
It says the person who's been taken into custody for a charge with or adjudicated delinquent. So it's got an or in there. May petition for the court expunging all official records relating to being taken into custody. I haven't really looked at it, Your Honor. I don't want to concede something, but at a glance in here, it does appear to apply to somebody who was taken into custody but not adjudicated delinquent. The class cases granting expungement, have been mass arrest cases in which there's a similar conduct all at the same time. That's not what we have here, Your Honor. I see my time's up. If there are any other questions, I will sit
All
down.
right, thank you, Mr. Smith.
Thank
you. I want to thank both counsel for their arguments. Our practice is I don't know if you're in the courtroom, is to come down and greet counsel. This is a Fourth Circuit tradition that was initiated by Judge Parker in the 1930s. And I think our court has remained unique in that regard. It's a little bit of an icon, and we hate to give it up, but it's only temporarily in view of the pandemic conditions. And so when you come back, we'll shake your hands, we'll greet you and hug you and anything else you want. And thank you for your arguments. You need a break? Okay. We'll proceed on to the next case.
No.
Good morning, Your Honors. May it please the court. Daniel Scott Harawa on behalf of the appellant Raymond Tate. I'd like to reserve 5 minutes for rebuttal. Over a series of cases, from Farmer v. Brennan to Hudson v. McMillan and Wilson v. Sider.
Did you say Farmer versus Brennan?
Yes, sir. The Supreme Court.
I understand. I know the case, but I didn't understand that was a Bivens case.
So I think, Your Honor, it is a Bivens case, and I'll explain why.
Well, I understand you have to explain that it's implied, but they didn't address Bivens in there, did they?
Your Honor, a Bivens question is an antecedent question to whether or not.
I understand, but the fact that we decide a case without addressing subject matter jurisdiction doesn't mean we decided subject matter jurisdiction in a case.
Well, here is why I think this court should recognize Farmer as a Bivens case. The Supreme Court has said there is no meaningful difference between various kinds of deliberate indifference claims. As the court said unequivocally in Wilson v. Sider, and I quote, "The medical care a prisoner receives is just as much a condition of his confinement as the food he is fed, the clothes he is issued, the temperature he is subjected to in a cell, and the protection he has afforded against other inmates."
Could you, my recollection is that discussion, which I agree, it says that, that's in the context of discussing what the scienter requirement should be. Is that right?
Yes.
Okay.
And Your Honor, and that's why in Carlson, in Farmer, and Wilson, the Supreme Court has made clear that it doesn't see any meaningful distinction between the various types of deliberate indifference claims. All of the claims involve prison officials who disregard a substantial risk of harm to the health or safety.
Well, that's probably the issue in this case, the level of generality that the Supreme Court has applied in determining whether it's an allowable Bivens case. As I understand it, Farmer really stands for the proposition that there is an Eighth Amendment claim with respect to protection against punishment from other prisoners or violence in the prison. And Carlson, I gather, is adequate medical care there. The person suffered from asthma and died while in prison. Is that right? Those two cases?
Yes, Your Honor.
In this case, we have a retaliation claim, I guess. I'm not sure what I'll ask you about that, but we also have mainly conditions of prison, alleged horrendous conditions of prison.
Yes, Your Honor.
Okay.
And Your Honor, the reason why that's not different, if you move beyond even the statements in Farmer and Wilson, where the court said, we don't see any meaningful distinction, if you apply the Abbasi factors, there's also no meaningful difference between the claim that Mr. Tate alleged here and the claim that was recognized in Carlson, and we argue was applied or implied in Farmer. So if you look at the ranks of the officers, it's the same. If you look at the type of claim, it's the same. If you look at the level of judicial guidance, it's exactly the same. So, Your Honor, we argue that the Abbasi factors, which this court has to apply in determining whether this is a new context or not,
made clear that this isn't a new context in any meaningful way. And if you look at the type of facts that the Supreme Court and this court have said makes a case meaningfully different, they're nothing like the facts here. So if you look at
Is this with regard to the failure to protect claim, the confinement claim, or both?
So, Your Honor, I think the failure, so right now I'm mainly talking about the conditions of confinement claim.
Not the failure to protect.
I think the failure to protect claim is the exact claim that was at least acknowledged or
Well, can I ask you then about the conditions of confinement? I worry that it is meaningfully different, maybe, and here's why. Because, you know, the case where the court says you have to provide medical care, that is a don't fail to treat this really serious condition, which, I mean, requires judgment. Don't get me wrong, it requires doctors, but it says don't fail to fix this one discrete thing. Whereas here, when I look at your conditions of confinement claim, I mean, and I say this advisedly, and I don't mean to minimize what sound like some very significant problems at this prison. It seems to be the global complaint is run a better prison in lots of different respects. And that starts to sound a lot more open-ended than don't fail to treat this one identifiable medical. So under Abbasi, why isn't that a different context?
So I think if we look back to Carlson, I hopefully can tease this out for you, Your Honor. So in Carlson, part of the claim was the adequacy of the facilities. And then part of the claim was the way the defendants reacted to the prisoners, in that case, medical condition. And the same thing is true here. If we are just talking about a prison with terrible conditions, then maybe that looks just like the medical facility. But there are also the inactions and actions of the defendants that exacerbated the conditions that makes it, in my view, not meaningfully different from Carlson. And so if I could give an example, and I hesitate because this may not be a good one, but let's say Bivens, an excessive force case, the excessive force was shaking the person around, right? And then the next case is the officer kicking them really hard in the shin or punching them in the face, causing different levels of injury. I don't think that is the type of factual distinction that would require this court to recognize a new Bivens context.
Sorry, give me the first situation in that hypo again. I just want to make sure I'm following.
So let's say Mr. Bivens was at home and he got shook up by the officers when they arrested him.
So they physically shake him. Okay.
Yeah, and then let's say the next plaintiff comes into court and says, no, the officer punched me in the face and it caused a lot of damage. I don't think that is the type of factual difference that makes a case meaningfully different from previous recognized Bivens claims. And none of the facts here are similar to the facts, again, in the recent Supreme Court cases. They all involve national security, foreign policy implications. In the cases that this court has looked at, they involve different constitutional amendments. They involve different classes of defendants. None of them involve the type of factual differences here. And then I think even if you look at the Supreme Court's decision in Egbert, which I know at first glance may seem to caution against recognizing Mr. Tate's Bivens claim, I actually think it's the opposite. So one of the reasons perhaps why the Supreme Court hasn't seen fit to overrule its trilogy of Bivens cases is because Congress legislated with the idea that there was a Bivens action available for certain kinds of injuries. So by the time Congress passed the PLRA in 1996, federal prisoners had been bringing Bivens actions in light of Carlson for almost two decades at that point. And those claims weren't just medical care claims. There were also conditions of confinement claims. There were also failure to protect claims, as in Farmer v. Brennan. And Congress, in overhauling the prison litigation process, left those claims alone. And you have to assume, as the Supreme Court said, that Congress legislates with the understanding of what's going on in the courts. And I think that is one reason why the court hasn't just seen fit to overrule these cases, because Congress has done a lot of legislating.
Can I ask you about that? I'm trying to figure out the strength of that inference, because of course, I mean, if the only conditions of confinement claims brought by prisoners were brought by federal prisoners, I think that's a fairly strong inference. But the vast majority of prisoners are state prisoners, and the PLRA doesn't just regulate Bivens actions brought by federal prisoners, it regulates the far more common example of Section 1983 claims brought by state prisoners. So what do I do with that fact? I mean, I guess one way to say it is, are there any provisions of the PLRA that apply exclusively to Bivens actions brought by federal prisoners and not 1983 actions brought by state prisoners?
Not to my knowledge, Your Honor, but the reason why I don't think that inference in the hypothetical that you just drew necessarily holds is because if anything, you would assume Congress would be just as cognizant of what's happening in the federal prisons over which the federal government superintends. And if the federal government wanted to foreclose claims in that context, it certainly knew how.
But maybe, but I guess I've always understood the PLRA as being more about the federal courts than anything else, that federal courts are being swamped by enormous quantities of prisoner litigation. There's some incredible percentage of federal civil litigation is prisoner litigation, and that the idea behind the PLRA was to reduce the burden on federal courts without necessarily caring where the prisoner is a prisoner.
I mean, I think in addition to that, though, Your Honor, it would be somewhat anomalous for Congress to say, state prisoners, we're going to create all of these obstacles before you can sue in federal courts. We're going to let federal prisoners continue to bring suit. In light of Farmer just happening just 2 years prior, we cite various cases in our reply brief that are from the year of the PLRA. So it's not as if these claims weren't happening at all. And so I think it would be strange to think that given the recency of Farmer, given the fact that these claims, even if they're not the vast majority of prisoner claims, they were being brought, and given the fact that these claims involve the federal government, of which Congress is presumably concerned, that Congress, again, the PLRA is quite comprehensive in scope. And the fact that Congress said nothing, I think, militates in a different direction than a lot of the other more recent Bivens cases that the Supreme Court has.
There's a lot of collateral discussion in both Ziegler and Egbert about that seems to undermine a little bit what you're arguing. I mean, first of all, I don't remember the court ever citing Farmer as a Bivens case, and they purported to list every one in their opinion. And second, they seem to think that they are not going to create causes of action under the Constitution and keep the tightest rope they can around just the three they have. As a matter of fact, they even expressed doubt about those three and saying that today we wouldn't even recognize those three. So for us to expand Bivens to another type of claimed prison conditions would be a substantial opening, because we do get a lot of prison condition cases, and they may be with some merit, because a lot of prisons aren't luxury hotels, and but the sense I take, and I think it's a fair sense from the Supreme Court's recent cases on this, is that we ought to be really cautious. As a matter of fact, they're not sure they want us to recognize anything except ones that are just dead on. I mean, they've cited differences that seem to me hardly are differences that they say are still take it out of the Bivens context. And
Sure. So if I can respond, Your Honor, the Third Circuit in Bistrian said, when discussing whether Farmer is a Bivens case, said the reason why the Supreme Court may not have seen the need to discuss it as a new Bivens case, because it was applying the exact same type of Bivens claim recognized in Carlson, which brings me back to Wilson and Hudson and Farmer, where they discuss all of these claimings as being somewhat fungible in how courts should view them. And I think it's not as if when Farmer was decided, the Supreme Court didn't have Bivens on its mind. That same year, FDIC versus Meyer was decided, in which the Supreme Court refused to recognize the Bivens remedy. So it's not as if Bivens was just in the shadows, just not on the court's docket anywhere. So I think the Third Circuit's kind of read of Farmer in that regard is a good one. And Your Honor, I think kind of your point about federal prisoners, and I think this goes back to the PLRA, is that all types of prisoner litigation claims are weeded out. Congress did that intentionally. I think it's more the fairer read of what happened here is that only the most egregious constitutional claims will even make it into a court past a screening. And to say that those people who are the most vulnerable in a society have no kind of redress for violations of their constitutional rights, and they have
the
no.
Supreme Court has addressed that exact question and says it's not for us to hear. You give that to Congress and have them create the causes of action. And it seems to me that's exactly the message they're conveying. They're saying we probably overstepped that corollary in our Bivens cases. And basically they said since then they haven't recognized a single case out of how many years? It's
I agree that the court has said that it probably overstepped and it is a new day when it comes to Bivens and the Supreme Court. But what the court hasn't done is overrule its prior cases because the Congress has litigated as if Bivens.
well, they've told us how to take those cases. In other words, they have the Bivens cases. And the question is, how specific does a future Bivens case have to be? How close does it have to be to the 3 that were adopted? And it seems to me, even if you accept Farmer, the argument is, the issue actually is whether protection from violence, protection of prisoners from violence of fellow prisoners, whether that's the same as conditions of prison involving dirty conditions, whatever, not adequate sleeping facilities, mattresses, and all that type of thing.
And I think, Your Honor, this isn't just an intuitive, are there factual differences? The Supreme Court actually gave us factors to apply to make that determination.
Yeah, I know.
And this court has applied those factors in at least 3 different cases, and none of those factors militate in favor of this being a meaningfully different. I think the word meaningful matters here. The Supreme Court, I don't think, used it accidentally. None of those factors suggest that this case is meaningfully different. And so, yes, there are going to be factual differences between each case. But I think being faithful to Supreme Court precedent and applying the factors, which my friends on the other side don't, because they only lead one way, and that one way is recognizing Mr. Tate's condition of confinement claim. And really quickly about the failure to protect claim. Again, we think that is the exact same claim recognized in Farmer. The district court didn't address it. The defendants did not address it. And so
I'm sorry, I know you're, can I ask one last question?
Of course.
On the failure to protect claim, the district court did say, I thought in the, in denying the motion for reconsideration, look, you haven't, your client hasn't alleged that, at least specifically as to him. There are allegations that this happens, but no allegations that it happened to him. Did the district court get that wrong? And where's the allegation I should be looking at?
Sure. So, Your Honor, I think the allegation is similar to the allegation recognized by the Third Circuit in Moore v. Mann. And what Mr. Tate's allegations were that the prison officials labeled him as gay, as coming on to male staff in the prison in order to incite prisoner violence against him. Now, I will concede that Mr. Tate does not allege that he suffered any violence at the hands of any other prisoners. But I think, as this court said in, I believe it was Porter v. Clark, whether or not somebody suffers violence doesn't go to whether or not they alleged a claim. It's more of a question of damages, excuse me. And so I think that those are the allegations.
Wait, why isn't it a question of harm in an injury of fact sense? I mean, if he doesn't allege that anything bad happened to him as a result, why isn't that just like bad government conduct in the ether that doesn't support standing?
Well, he doesn't allege physical harm. He does allege mental suffering, Your Honor, as a result of the allegations.
Okay, thank you. You have some rebuttal when we come back. Yeah. Ms. Frith?
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Krista Frith on behalf of the 12 BOP employees sued in their individual capacities by Mr. Tate. This court should affirm the district court's dismissal of Mr. Tate's complaint because in Egbert against Boulay, the Supreme Court foreclosed any damages remedy for inmates against BOP employees for unlawful conditions of confinement. In Egbert, the Supreme Court held the question of whether a damages remedy exists boils down to one question: whether there is any reason to think Congress might be better equipped to create a damages remedy. If there is one rational reason, just one, which the Supreme Court emphasized.
Can I ask you a threshold factual question that the parties seem to join issue over? Would the Westfall Act preclude a state law lawsuit in this instance?
Not necessarily. The Westfall Act would require the Attorney General to determine that the individual employee was acting within the scope of his employment. So to the extent the Attorney General did so, then yes.
And as a former government employee, would it be
would I be wrong in surmising that the Attorney General very rarely concludes that BOP officials were not acting in the scope of their employment?
That is my understanding. However, I do know there are instances where BOP officials are clearly acting outside of the scope of their employment, and the Department of Justice prosecutes.
Well, sure. I mean, if they assault a citizen on the street, that's pretty easy. But how often does the Attorney General conclude that something a BOP official does in a prison to a prisoner is not in the scope of their employment?
Prisoner on prisoner. I'm sorry, I missed.
How often does the Attorney General conclude that something that a prison official does to a prisoner inside a prison is not within the scope of their employment?
I don't have any data on that, Your Honor. But for example, there are cases where a BOP employee does not conduct his requisite rounds, and as a result, an inmate is murdered or commits suicide. And those BOP officials have been prosecuted by the Department of Justice for failing to do those rounds and lying on their log sheets about doing those rounds. Going back to Egbert, the court noted that the answer as to whether Congress is better equipped to create a damages remedy is yes, in quote, almost every case.
Counsel, just so I understand the order of operations, I mean, if this were a medical, inadequate medical treatment claim, are you suggesting that we would start by saying, is there a reason that Congress would be better positioned than the courts to decide this? Oh, yes, there is. So there's no claim. Or don't we start from the fact that Carlson is good law, and is this an extension from Carlson or not?
Your Honor, under Egbert, no, we should start with the.
So you think we're free to overrule Carlson? Like if I think Congress is better situated than this court to create a cause of action for failure to provide adequate medical care in prison, then this court could decide today Carlson is no longer good law?
Yes, Your Honor, under Egbert.
Wow, that's very forward looking.
I thought the Supreme Court recognized Bivens' claims.
Yes, it did. It invited the opportunity to overturn Bivens.
I understand, but they decided Carlson, and it's still good law today, isn't it?
The outcome of Carlson, the Supreme Court.
No, the holding of the Bivens action in Carlson was upheld, was it not?
Yes, it was, Your Honor.
But you
Right
think
now, if we
get
had
rid
a
of it?
case under Carlson, then we would have to recognize that case, would we?
No, Your Honor, and this is why.
You mean we're gonna flout the Supreme Court's holding?
No, Your Honor.
Well, that sounds to me like what you just said.
Under Egbert, the analysis in Egbert, the Supreme Court explained, even if there are parallel circumstances, which the Fourth
Well,
Amendment.
every Bivens action falls into your case, and the court chose not to overrule Bivens.
It did in the facts and
I mean, you get the Fourth Amendment case in Bivens itself.
Yes, Your Honor.
And Congress could easily take care of that.
Yes, it could, Your Honor. And in Egbert, the Supreme Court said that even if there are parallel factual circumstances.
No, that was a different part of the analysis. That's at the back end about special factors. And the argument is you can't any longer say, look, in Carlson, there weren't any special factors. So there ought to be no special factors in my conditions of a confinement case either, because it would basically be the same thing. But you understand the Supreme Court in Egbert to have invited the lower courts to go ahead and get rid of Carlson, Bivens, and Passman.
I mean, the courts would basically overrule, the courts would
That's what you're
overrule.
saying.
Not directly, Your Honor, because what Egbert did in the Fourth Amendment discussion is that even if there are parallel circumstances, you must still look to determine whether there's any rational reason Congress is better suited to create a damages remedy.
I've assumed that was exclusive of the Bivens cases recognized. In other words, it seems to me the first analysis is this an authorized Bivens claim? If it is, it goes forward. If it's not, then before you extend Bivens, you have to conduct the analysis, including the quote you just gave us. But I didn't see the Supreme Court inviting the lower courts to overrule its decisions.
Under Egbert, I think Carlson.
You don't need to argue this harsh. But go ahead, continue.
Well, I am interested in your theory of why it is that we can overrule Supreme Court cases now, because I have a whole list.
Well, and perhaps I did not address this question sufficiently. we're not suggesting that this court overrule Carlson, and we are not asking for that. That is not before the court. We have not argued that. But
are you
what-
saying if we are presented with a case that is materially identical to Carlson, we should say there's no Bivens action?
Not necessarily. You still have to do the special factors analysis, and that's what the court did.
Well, the special factors, it's the same case. The hypothetical given to you is that we have the same case, factual case as Carlson.
Except his name is Smith now.
Yeah, now it's Smith
He has asthma. They don't treat his
Yeah,
asthma. They
yeah.
give him
And
a
he
comfort.
dies.
Right.
in prison. So we have that case before us, and we conclude that Congress could well have addressed that medical care in prisons should be equal to the level of provision of medical care in the community or something like that, and create a cause of action. You're suggesting that if we reach that conclusion, we shouldn't follow Carlson, right?
Correct, Your Honor. And this is because this is what the Supreme Court explained on page 1805 of Egbert, that if there is any rational reason that the court did not consider in Bivens, Passman, or in your hypothetical Carlson, not to extend a Bivens remedy on those facts, then it should decline to do so.
But we're not extending it. It's in our hypothetical, it's just Carlson.
Correct. And again, if
It seems to me that demonstrates that analysis comes in only when we have the question before us of whether to extend Bivens.
yes, Your Honor, and it is our reading of Egbert that regardless of whether it is a new context, the court must still employ a special factors analysis. But we've perhaps gotten far afield because this is not the case of Carlson. This is a new context. But most importantly, there are.
But I understand just, are you changing your view now, or do you think if we had a Carlson case now, we should overrule it?
No, I'm not changing my view, Your Honor.
I mean, so we should overrule Carlson if we had a direct Carlson case and we concluded that Congress could address it.
Yes, Your Honor, and I don't think the court would be overruling it because I think Carlson is under questionable ground after Egbert. The Supreme Court explained in Egbert that its reasoning for its holdings in Bivens, Passman, and Carlson is no longer valid. That is not the analysis that the Supreme Court employs for Bivens cases any longer, suggesting that those three holdings are on very shaky ground. And if the precise factual scenario was again before the court, it is very likely that the court may not find there to be a damages remedy.
Hasn't the Supreme Court said several times that even when its decisions appear to us to be on shaky ground, we are not at liberty to overrule them? We have to go ahead and wait for the Supreme Court to act first?
Yes, Your Honor. And again, we are not asking for this court to overrule Carlson. And this court does not need to do that to affirm the district court's dismissal.
Well, this was a hypothetical discussion based on the fact that we had before us the same facts as Carlson. And I guess our questions show some surprise that you would even attempt to reach that far. It seems to me your argument is here today that this is not a Carlson case.
Yes, Your Honor, this is not a Carlson case. This is a new context. There are very meaningful differences, and no matter how close the cases may seem, the Supreme Court time and time again, even in parallel circumstances, has still found it to be a new context. For example, in Abbasi, the Supreme Court acknowledged it was very similar to Carlson, yet it found it was a new context. In Malesko, the Supreme Court also acknowledged it was very similar to Carlson, yet it was also a new context.
Can I ask you a specific question about the failure to protect claim? I assume well, I guess you don't represent 1983 defendants, but is your understanding that to bring a failure to protect claim, you have to allege that something bad happened as a result of the failure to protect?
There needs to be some injury, does not necessarily need to be a physical beating, for example, but yes, there does need to be some injury to have a cognizable failure to protect claim.
Well, and then don't cases like Los Angeles versus Lyons establish that an inchoate fear that something might happen is generally not a constitutionally sufficient injury?
That is correct, Your Honor. And so you would have to plead sufficient facts to show that there is some injury beyond just a fear that something would happen. And Mr. Tate has not alleged those. He did not allege a failure to protect claim, and he did not argue a failure to protect claim in his opening brief either. He cabined it.
Well, assume for the sake of argument that I think he has alleged a failure to protect claim. Is the fact that he may not have alleged that anything concrete happened to him as a result fatal to such a claim?
Yes, we would take that position, Your Honor, because in order to have standing to bring such a claim, he would need to allege some sort of injury as a result of the failure to protect. With respect to the special factors analysis, there are three principal reasons that Congress is better suited to fashion a remedy. First, there's alternative remedies. Second, separation of powers. And third, system-wide consequences. First, looking at alternative remedies, there is the BOP administrative remedy process, which the Supreme Court acknowledged was sufficient in Abbasi, which this court found was sufficient in Earl against Shreves. The 10th Circuit found it was a sufficient reason not to extend a Bivens remedy in Silva. And the 9th Circuit recently found it was a sufficient reason not to extend a Bivens remedy in Hoffman. As this court explained in Tunkos, it does not need to be a perfect remedy. The purpose of the alternative remedy is to have a deterrence effect. And there are other alternative remedies that provide that effect as well, such as the fear of criminal prosecution. There's also the Office of Internal Affairs that investigates BOP employee misconduct. There's also the DOJ Inspector General. These investigations and the fear of criminal prosecution provide a significant deterrence and punishment for employee misconduct. Egbert also discussed that as a sufficient reason not to extend a Bivens remedy when it found that the internal investigation process used within the Customs and Border Patrol was a sufficient reason not to extend a Bivens remedy in that case.
Counsel, I'm sorry, can I take you back to what I had thought we all assumed was sort of the first question, which is this an extension of Carlson or not? So your colleague's case, makes on the other side makes a case. I probably can't paraphrase it as well as he said it, but that either way, whether it's this kind of a conditions of confinement claim where the allegation is this is a risk to health, there's mold, I could get sick. Either way, through deliberate indifference, you have prison officials who are exposing a prisoner to a known risk to health or safety. Is it really why is it a meaningful difference that in one case they do it by making you sick and in another case they do it by not fixing you once you're already sick? Why is that meaningful for these purposes?
Yes, Your Honor. So for example, we could look at the differences in the defendants. In Carlson, you had the doctors and other medical professionals who failed to provide the requisite medical care to the inmate as defendants.
But sometimes the defendants in those medical treatment cases are not doctors. Sometimes they're just the line officers who don't get the person to the infirmary or something like that.
Yes, Your Honor. If we look beyond just the defendants, though, and let's look at the facts of Carlson against what Mr. Tate has alleged. In Carlson, Mr. Jones was hospitalized for 8 days due to an asthmatic condition. The physician recommended he be transferred.
Well, actually, I am very familiar with the facts of Carlson, but I guess maybe if you could just jump to the one that makes this a meaningful difference.
We have to look at all of the facts. And so we have significant and repeated failures of the defendants in Carlson that led to a really egregious outcome.
Oh, is it how egregious the violation is? Is that what you're saying? That's the meaningful difference?
No, Your Honor.
Okay, because I don't know any cases that say that.
The difference is the failures. I am just acknowledging that the outcome in Carlson was egregious. And in many of these cases, we do have unsavory facts. But with respect to the differences between Carlson and Mr. Tate's claims, we have repeated failures by medical staff to provide requisite medical care, failures to comply with doctor's orders, failures to have functioning equipment, failures to have licensed medical staff.
I guess what I'm asking you, and again, I don't mean to cut you off, and But for instance, Judge Heitens had a suggestion for why this might be a meaningful difference. Does the government have a position as to why the factual differences that you are reciting are meaningful? Because I actually understand now in a way I did that the government is not conceding that we couldn't overrule Carlson. But if we had a medical treatment case and it wasn't asthma, it was a heart problem, and the prisoner asked 4 times for heart medicine, not 3 times for asthma medicine, I actually don't think the government would be here saying, oh, those are meaningful differences. So what I'm asking you to tell me is what makes these factual distinctions meaningful for purposes of knowing whether we have moved past Carlson or we just have slightly different facts?
One is in the provision of life-saving medical care, and one is in the provision of things like toilet paper, a mattress, and
but also exposure to a health risk in the cell. That is alleged that I was exposed to mold that would make me sick.
yes,
So it's not just toilet paper and mattresses.
Yes, Mr. Tate does allege that he had mold exposure in his cell. I don't believe that he alleged that it was making him sick or he had some allergy to the mold. And that he was given cleaning supplies, but was not given sufficient cleaning supplies to address the mold. Those are very different allegations because, again, one is in the provision of failure to provide medical care, whereas the other is with respect to, I'll call them creature comforts, with respect to the cleanliness of his cell, the amount of toilet paper he's provided, the size of his pencil.
Then imagine a hypothetical where he says, there are vermin in my cell and I am going to get bitten and get sick. So take out creature comforts, okay? Let's talk about really bad and bad conditions that present a risk to health. Is that meaningfully different from Carlson?
Yes, Your Honor.
Okay, how come?
Because one is in the provision of medical care and one is not in the
This
provision.
seems like a tautology. I'm asking you, why are those two things meaningfully different?
Yes,
And you're just saying because they're different.
Because one is with respect to how following doctor's orders and how to interpret and provide medical care, and the other scenario is not. And there's also a comedy, a waterfall of things that happened in Carlson. So, for example, in Carlson, if it was just one incident, right, he goes to the hospital for 8 days and is released with the doctor's orders that he be transferred to another prison, and he's not. That would be a meaningful difference from the actual facts of Carlson. So it's several things. The cumulative but the cumulative facts of Carlson need to all be looked at, and those are not the facts that Mr. Tate has alleged here. In Egbert, the Supreme Court cautioned lower courts with the watchword of caution when asked to imply a Bivens remedy. Here, alternative remedies, separation of powers, and system-wide consequences demonstrate Congress is better suited to create a remedy. This court needs just one reason. Therefore, it should affirm the district court's dismissal. Thank you.
Thank you. All right, Mr. Harawa.
Yes, thank you, Your Honors. Quickly, so I think this goes to Judge Harris's question. It's not just a freewheeling, let me point to facts to decide what makes a case meaningfully different. The Supreme Court gave us guideposts in Abbasi that said these are the types of factors that makes the case meaningfully different. None of the facts pointed to by my friend on the other side are any of the same factors outlined in Abbasi. And in fact, if you look at every Bivens case, Hernandez was a cross-border shooting involving national security. Egbert was a border patrol agent involving national security and immigration concerns. Abbasi was a post 9/11 case involving national security concerns. So all of those cases, that's what makes the case meaningfully different. It's not just, well, the facts, if you look at them here, are just slightly different or different in some way than the facts here. And that's why I think.
Well, let me ask you this. It seems to me if a legislator was facing these different claims and deciding what remedies to provide, they might look at these two circumstances in the following fashion. They may say, in prison, we're going to provide doctors of certain caliber. We're going to require treatment. We're going to require this and that. We're going to require an infirmary and this type of thing. And whereas in conditions of prison, they would say, okay, we're going to require certain level of mattresses. We're going to require certain level of toilet paper. We're going to require that the prisoners be given sufficient utensils to clean up their things. It seems to me they would be talking about different things, even though at some point of analysis, as Judge Harris's questions point out, there comes to be some similarity. So that it seems to me that we focus on, is this really a different context? Is this a different issue that would be addressed legislatively? That type of analysis hurts you more than the more logical analysis, which is the legal analysis of how does prison conditions different from withholding medical care?
Your Honor, I actually,
It's not a slam dunk anywhere.
and I actually don't think the legislative concerns necessarily are as different.
No, but I think that's sort of the mentality of the court was, these are types of remedies that legislatures would address. And if we would find that there are different remedies, then it seems to me that we may have a different context. But I may be wrong on that. I mean, the point is, they really wanted us to be fairly strict about this. It seems to me that's a message I take through these cases. And so the question is, what level of requirement do we have? I gather if we had a Carlson case, you would ask us to follow Carlson, would you, and not overrule it?
I don't think you have the power to overrule it, Your Honor. And in fact, in Federal v. Lynch, which was decided just last year, this court allowed a Bivens case premised on inadequate medical treatment to proceed. And I didn't see the court calling Carlson into question there. But Your Honor, and that's why I don't think Egbert overruled, and it certainly didn't overrule its more recent Bivens cases, Abbasi, which told us how to do the analysis. And even though Justice Thomas and Egbert didn't tick through the first Abbasi factors, he made clear the factual differences that made Egbert different from Bivens would fit within the factors outlined by the Supreme Court in Abbasi. And that's why—
But didn't they even talk about, I can't remember it now, but didn't they even talk about different defendants and different, I mean, the stuff they talked about as material in other types of contexts might not be considered material. But even who you would name as defendants, I think, that type of thing.
And again, it's true, Your Honor, but none of those differences are, even if they seem immaterial, they're not even those differences aren't implicated here.
Well, it might be. I think it's a fair claim that in Carlson, the healthcare providers failed, and that's who were sued as defendants. And here it would be prison officials for the general conditions of prison. Now, obviously, you can have facts in the medical context where prison officials also didn't facilitate the medical treatment. But I don't even know if Carlson would reach that. It might, but that's the type of problem we have to analyze.
And if I could be really brief, Your Honor, because I see my time is up. Carlson also involved, the defendants were also line prison officials. They weren't just the medical staff in Carlson. And the Supreme Court did essentially—
That's a good point.
Draw that distinction. And I think Judge Harris's hypothetical is much better than mine, really shows why these two claims, it breaks down to say, I can leave you in your cell until you're sick, but then once you are sick, you have a remedy, versus why don't I just give you the condition of your cell so you're never sick in the first place, so therefore you don't need medical care. And I think if anything, the legislative prerogative would be to address the former situation and not the latter. So we respectfully ask that the court reverse.
Okay.
Thank you.
Thank you. Mr. Araro, your court assigned on this. I want to thank you for your service. It's been excellent. I think you've made wonderful arguments, and this is what makes our system special in the world. We would come down normally to greet you. We're keeping the pandemic protocol is still in place, so we're not going to do it this time, but we will again when you come back. I know you'll all be back. It's I think, have you been here recently? Were you? I apologize. I withdraw my question. Thank you very much. Okay, we'll adjourn court for the day. Yeah.
The honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Maybe I should come down as a person and shake his hands.